people knew, exposing every move, every tyrant, every badge, every lie. They approve from Mississippi to Texas up to Utah too. You retaliate against the truth, and the truth hits. They've been doxing my address, running interstate crews, marshal judges, dirty cops, all the bad actors in view. I survived every trap that your government used. Now I'm back with the facts. We the people knew. Yo, started in Mississippi when the Tannehills lied. A restraining order forged just to keep me outside. No bonfire, no cause, just political pride. And 7 years later, that fraud still rise. Then the state doubled down, built the case off a myth. NBI in the shadows with a badge and a twist. Stalking charges built on my journalism hits. Fabricating affidavits like they reading from a script. Galveston it next on steam fake. What he smelled, claimed odor of alcohol, but the tox screen yelled. Zero content detected, still they tossed me in a cell. 11 months in a cage while they manufactured hell. The Mississippi called Texas revocation by request. Leavers lied again and the judge said yes. Sentenced me to 2 years all fabricated stress. Later vacated, overturned, but I still paid the debt. That's the playbook they use when the truth breaks through. Retaliate, suffocate, silence what I do. But I never stop filming, never stop pushing through. Cause the people need the facts. We the people knew, we the people knew. Exposing every move, every tyrant, every badge, every lie. They approve from Mississippi to Texas up to Utah too. You retaliate against the truth, and the truth hits you. Been doxing my address, running interstate crews, marshal judges, dirty cops, all the bad actors in view. I survived every trap that your government used. Now I'm back with the facts. We the people news. I moved west to Utah, trying to rebuild clean, but laying PD in Oxford ran across jurisdiction scheme. Systems pulled my data, richness blasted out the screen. Doxed my private new address, 1 hour on scene. In a ring to deny records, he knew I could redeem. Grammar twisted into weapons like a county machine. Said a mailbox ain't valid, what the statute they mean. Just obstruction in the trench with a retaliatory lean. Try filming DHS, trespass for walking through. Try filming in airports, ain't retaliatory cue. Every camera that I raise is a threat they construe. But filming ain't a crime, it's a First Amendment view. So I took it to courtrooms, files, who's by the stack. Every brief, every motion is me taking it back. They can lie, they can smear, they can launch their attacks, but the truth is a force that the tyrants can't crack.
Back on June 27th, I put in a FOIA request to the U.S. Marshal's Office regarding what I knew was some type of multi-state interstate cooperation, a conspiracy to target me as a journalist and to silence my voice. And so I put in a FOIA request to the U.S. Marshals Service after a particular event happened in Lafayette, Louisiana. Those on here that have been following my channel for a while know the things that have happened with Galveston, involving the interstate cooperation from Lafayette County, Mississippi, to have me framed for a crime that never actually occurred in order to throw me into prison. The prison sentence, of course, was vacated, declared unlawful January of this year, and I was released. It didn't stop the conspiracy there. It continued on. I moved, as soon as I got out, a week later, I moved out to Layton, Utah. And when I was out there, I found out through public record request that there was a targeted campaign that had gone on involving an Oxford, Mississippi police captain by the name of Hilton Sessoms that reached across state lines 1,700 miles away, somehow, some way, found my address within a day or two of me moving out to Layton, Utah, disseminated that address out to the local police department up there in Layton with defamatory information. My address, my private information was then doxed out to 139 police officers up in the Layton, Utah area. This has grown out of control. The extent of this conspiracy that has continued and continued and continued. I go down to Lafayette, Louisiana, and Jonathan, supervisor with the marshal's office, the second interaction that we had at the courthouse made it clear that he had obtained information. He had come across information and given the track history of what had happened with Galveston, and given the track history of what had happened with Layton, Utah, I had absolutely no doubt in my mind. You don't just fall into this information without it being communicated. Okay? This is all part of the larger plan at place. So what I did is I did a FOIA request. I'm going to read this. It's a Freedom of Information Act request sent June 27th, 2025. The FOIA officer for the United States Marshals Service, the Office of the General Counsel in Washington, D.C. Dear FOIA officer, pursuant to Freedom of Information Act, yada yada, I'm requesting access to and copies of the following documents and information. Number one, all communication, emails, letters, faxes, memoranda, reports, notes, text messages, bulletins, bolos, or any other correspondence sent to or received from Lafayette County or Oxford, Mississippi, and or any law enforcement or government entity or official therein, including but not limited to the Lafayette County Sheriff's Department, Oxford Police Department, Lafayette County Circuit Clerk's Office, or any other government official or agency, referencing or relating to myself, Matthew Oliver Reardon, also known as Don Matthews, from January 1st, 2025 to the present. All internal bulletins, BOLO, be on the lookout notices, advisories, alerts, or any other information or communication distributed internally or externally to any law enforcement agencies or federal offices referencing or pertaining to me, Matthew Reardon or Don Matthews, following incidents occurring on June 23rd, 2025 and June 26th, 2025 at the U.S. District Court, Lafayette, Louisiana. Any and all communications or transmissions, internal or external, referencing any prior interactions with any law enforcement agencies or court entities in Lafayette County, Mississippi, Galveston, Texas, or Layton, Utah, specifically concerning or referencing alleged criminal history, prior litigation, civil rights activism, journalism activities, or any other investigative information gathered or transmitted. This was sent June 27th, 2025. Here it is, August 22nd, 2025. They're generally given 20 days to respond to a FOIA request. Of course, they're well past that. And I was actually going to be reaching out today and figuring out why the hell I haven't gotten my FOIA request. Because clearly something's going on here. Okay? Today I got a letter back from the General Counsel for the United States Marshals Service regarding the FOIA request. The U.S. Marshals Service is responding to your request received by the U.S. Marshals Service on June 27, 2025 for everything that is notated. Provide you with the greatest degree of access authorized by the Freedom of Information Act and the Privacy Act. We have considered your request in light of the provisions of both statutes. The records you seek are located in a Privacy Act system of records that, in accordance with regulations promulgated by the Department of Justice, is exempt from access provisions of the Privacy Act. Accordingly, to permit access to the records, your request was processed under the provisions of the FOIA. Long story short, what they did is they provided me 14 responsive records that are heavily redacted. Of course. This is our government for you. They don't like transparency at all. At all. Share this live stream. People need to see it. Okay? Put it up here. People need to see this. Here's the records. Friday, June 27th at 3:35 p.m. As you notice, the from is redacted out. The to is redacted out. The CC is redacted out. 3 different people, it is redacted out. Look at all these redactions, folks. Happy Friday. Please see the above alert notice and district court electronic device policy and share. Oh, let me say this. The attachments, okay? Subject is alert notice. The attachments, Matthew Reardon, district alert notice, okay? First Amendment audits are becoming a fast-growing trend at federal courthouses. Don't play their game. Just follow your training and local orders policy from the judiciary. There's a redaction right there. I do not have a copy of the electronic device policy for bankruptcy. I don't know why there's anything about bankruptcy, because there's never anything said about bankruptcy. I've never filed it. Not sure what that's about. This is from the Supervisory Deputy U.S. Marshal for the Northern District of Mississippi. All right, I'm over in Louisiana. Why is Mississippi continuously involving themselves in matters of mine and reaching across state lines? Then on June 30th at 10:45 a.m., we have once again a redaction here. 2. Redacted person. Subject regarding First Amendment Auditor Matthew Reardon. Good deal. I may use your photos. All these redactions. I put this out Friday to my CSOs on Reardon. He is banished from Oxford until September 30th, 2027. But I expect he will show up in Greenville or Aberdeen sooner than later. In case you don't have this photo, here you go. Okay? They're passing it along to multiple individuals within the U.S. Marshal Service and the Department of Justice, as well as other local officials. All these redactions. For your information, be aware, once I get a bolo, I will send it out. Then down here at the bottom, it says, guys, apparently this guy is hitting the federal courthouses in Mississippi and Louisiana. Next page. We will try and get a bolo, pack it together. But until then, use this as for your information to the guys. Greetings, Southern District, U.S. Marshals. I have attached reports detailing the encounter with Matthew Reardon. Feel free to pass along to your staff. Look at all these redactions. Look at all these names. 2 blank, 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 CC blank, 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 blank. Like 8 CC'd right there. Greetings all. On yesterday, Matthew Reardon, a proclaimed First Amendment auditor, was in the lobby near the CSO screening station recording live streaming with a cell phone. I've attached a copy CSO report and a draft my report detailing the incident. Please pass this on to your staff to remind them to report any suspicious behavior, no matter how small, to any USMS personnel, CSO, or outside guard. Feel free to contact me directly if you have any questions or concerns. From the Supervisory Deputy U.S. Marshal for the for Lafayette and Lake Charles. Now, I am appealing all of this. I want you to know I 100% intend to get these redactions because this is in the interest of this is in the public's interest that this conspiracy is going on. It has wrapped itself up in multiple states, and I'm 100% willing to press forward with litigation and sue over this because it has involved itself in so many states with this reaching across state lines, and it's conspiracy. It's conspiracy, conspiracy, conspiracy. June 27th at 1:54 p.m. Reardon conviction documents. For our earlier conversation, here's his conviction docs from stalking the mayor here in Oxford. It is a felony conviction, and he is on unsupervised release. From what I'm told, without a felony charge and probably conviction, they likely wouldn't do anything with him on the state side. I watched the video posted yesterday. You mentioned a DUI arrest to him. Where was he arrested for DUI? In preparation from showing up at any of our sub offices, I'm going through our local rules. They are conspiring to try to, once again, get me locked up right here. They're talking about that I need a felony conviction, a felony charge, and probably conviction in order for the state to do something, to silence me. This is major. This is major, major, major. And if you don't think that this type of stuff can affect you, think again. Because they're showing that they can do this to me, they can do it to anybody. All right? The 2022 stalking charge involving the mayor, what they conveniently left out, and what I've claimed steadfastly from the beginning, walking through City Hall, requesting public records, recording my presence, that was never stalking. They fabricated the charge completely. They had lies told by a bullshit-ass FBI agent by the name of Joey Monty, who the video evidence even contradicts 100%. Didn't matter. They completely denied due process, and what I've said since day one is the state of Mississippi and Lafayette County manufactured a family crisis in my life. I had a son that was fighting for his life in the neonatal intensive care unit at Le Bonheur Hospital. My wife conveniently got fired from her job 2 weeks after my public defender went to work for the mayor's husband. Okay? Just dropped off the map. All of a sudden went to work for the mayor's husband, Ray Tannehill. Started August 15th. And less than 2 weeks later, my wife conveniently gets fired from her job at RedMed in Hernando. I got the page of notes from Mitchell Driscoll that was actually in another discovery file that has her name written on the page, where she works, her phone number, and the position of what she does up at RedMed. And he goes to work for Ray Tannehill, for the husband of the quote-unquote alleged victim? Are you kidding me? And then she gets fired from her job. Tell me that that's not conspiracy. I 100% allege, and I've alleged since the beginning, that this was completely fabricated. They completely manufactured that crisis in order to force my hand because I needed to get out of jail. I was held on a no-bond hold on a completely bogus charge, and they twisted my wrist by using my family to get me to flee out. But you know what? The feds don't want to make any mention of that. The Department of Justice wanted to swat me away like a fly. They don't want to look at the facts on everything because they're guilty of sin. June 27th, 1:54 p.m. Per our earlier conversation, here's his conviction docs for stalking the mayor here in Oxford. Okay, yeah, I already read that. District alert notice. Okay? The purpose of this district alert notice is to inform all operational employees and court security officers of Matthew Reardon. Should he appear in person, please monitor this subject closely and notify blank or blank. Redacted. All right? They 100% have to release these details. These redactions have to come off. I'm going to file a lawsuit to get them removed if they don't remove them on appeal. Background. Reardon has recently been frequenting local, state, and federal courthouses to conduct what he describes as First Amendment audits. In the past, he has been more cooperative than his current videos show. Refer to your training and local rules from the judiciary on how to handle this type of encounter. It's got my information listed right there. This is Ebola, okay? This has my pictures. Hey, they've circulated my pictures around. Unclassified court facility incident report. It basically talks about what happened right there. I'm going to publicly release this stuff. Fuck what they say about keeping this information private. The public has a a right to know. There was never any crime committed. All these redactions. On Monday at approximately 1600 hours, Supervisory Deputy U.S. Marshal Blank received a call from Deputy United States Marshal Blank about an unknown individual recording video in the courthouse lobby outside the security screening station. The individual refused to leave, stating it was his First Amendment right to record the film video in a public area. STUSM instructed DUSM to call Lafayette PD for assistance. 425, STUSM encountered an individual who introduced himself to be Don. Don stated he has no official business in the courthouse and he has a First Amendment right to record inside the building. After various conversations and several insults towards deputies and PD officers, Don refused to exit the building and suggested that STUSM arrest him. STUSM informed Don that he would not be arrested because he had not done anything that warranted an arrest. There we go, no crime committed. Moreover, STUSM asked Don, since he was in the building and had captured video footage, it would be best if he exited the building if he didn't have any official business to conduct. Yet Don still refused. Later, after discussing the issue with a USA criminal, I would imagine a criminal U.S. attorney and a assistant U.S. attorney, STUSM decided to close the building since all courts had adjourned for the day to get the individual to leave the premises. At approximately 4:48, Blank instructed the CSOs to close the building to the public. Don was instructed to exit the building due to the closure. While exiting, Don became belligerent, yelling obscenities towards LPD officers and STUSM. Next page. You've got me right there on security cam. You've got my picture right there that they circulated again. Okay. This is actually interesting. On Thursday, this is the second follow-up visit. On Thursday, June 26th, Matthew Reardon and Blank entered the U.S. courthouse. Now, why did they redact out his name? They never actually got the individual that went there with me. Why is his name redacted? Why did they redact Brandon's name right there? This is very, very, very fishy. Entered the U.S. courthouse with their cell phones recording video of the lobby. When STUSM Blank contacted Reardon, he stated he needed to file a complaint. STUSM asked about what? Reardon said it was about STUSM Blank, to which STUSM Blank advised Reardon to contact the U.S. Marshal Service headquarters in Washington, D.C. Blank asked Reardon if he had official business. He said he had no business. That's a lie. I said I was there to file a complaint. Okay? This is right to stand inside of a public building and record video. Reardon further stated STUSM Blank was unaware of the rules posted in the lobby. So STUSM Blank lightly placed his hand on Reardon's upper back, stepping in the direction of where the sign is posted so that we both could read the rules. Reardon suddenly jerked back, taking an offensive posture, and shouted, "Don't put your hands on me, motherfucker. That's assault, and I will have to defend myself." I did. Reardon and Blank continued to create loud and unusual noises by yelling obscenities and insults, demanding to see a judge. Moreover, they continued to disrupt the lobby and refused to leave and stop recording, which impeded the performance of official duties by government employees. In that, court security officers had to focus their attention on Reardon and Blank, which hindered effective security screening of people entering the building to conduct official court business. Nobody ever came into the building to conduct court business. This is all lies. This is lies told by the officials, okay? Furthermore, during the disruption, two unknown individuals entered the building to which Reardon and Blank demanded their names and badge numbers, telling them they were on camera. It was recently discovered these two individuals were special agents with the Drug and Enforcement Agency entering the building to conduct official court business. SDUSM blank continued to communicate to Reardon and blank that they can't come into the courthouse, be disruptive, and report because local rules and standing court order prohibited possession and use of electronic devices in the courthouse. Finally, because of Reardon's erratic behavior and inability to reason, SDUSM asked Reardon had he been drinking, and Reardon responded, "I haven't had a drink in 5 years, motherfucker," and that he had been with blank all day. SDUSM also asked about him stalking a public official in Oxford, hoping he would take note of the legal consequences and leave the courthouse. Reardon and blank continued to be loud and disruptive, saying they got what they needed, saying "it's my ass." They both exited the building, yelling and cursing. I'm going to quickly go through these other ones right here. 12 blank, blank, and blank. Hey, we need to be reminded what had happened on that follow-up visit. So we're going to do that right here, okay? And see what a lying sack of shit Jonathan really is.
Huh? Yeah.
How you doing?
All right.
You didn't get what you needed the other day?
No, I need to submit a complaint
About what?
about you, about the officer response.
Okay. And
So-
complaint for me, what I do to you?
Well, I thought that honestly you didn't know your rules and regulations governing conduct on federal property.
What are you here to do today?
I was here to figure out how to submit a complaint.
Okay. We don't do any complaints here. You contact the Department of Justice in Washington, D.C.?
I can.
Okay.
I certainly can.
We're going to start there. How about that?
Yeah. So by now you know my name. You know that this was not some just random occurrence that I popped into here. It was not some it wasn't like I didn't
Are you
know what I
recording
was
right
doing. I'm always recording.
Okay, so why are you here to record? What are you here to record?
Well, I'm a journalist once again, so I don't need to explain that
So
to you.
did you get any permission from the building tenants?
Don't need permission.
I think
and,
so.
and no, this is a federal courthouse.
It is a federal courthouse, but before you can come in here and record, you need permission.
That's incorrect.
from the tenants.
No, actually, according to that
let's
sign.
go over here,
No,
let's go right over
hey,
here.
get your hands off me. That's assault. It's assault. Don't put your fucking hands on me again.
Don't curse it.
Because if you put your
Don't
hands on
curse
me again, I'm swinging back.
You swing.
I'm swinging back the next time you put your hands on me.
Well, if you want to swing, you can do that. But you don't want to do it.
Well, you put your hands on me, I have the right to put my hands back on you.
I'm just. You want to walk over here? And let me show you?
No, we're not, because I know it's going to happen again.
You don't want to
Y'all
walk
going to
over
come
here
and block the door again.
We have the rules right here.
The rules, I showed you the rules.
Well,
I showed you the
there's a
rules.
picture to the thing right here.
I showed you the rules. I showed you the rules.
So, what business do you have here today?
Huh?
What business do you have here today?
What
business you got?
We're going to film.
Film what?
You right now.
You didn't give the day though? On Tuesday?
You're just going to make yourself look worse and worse. I have every right to be here. I have a legal right to be here. It's on the rules and regulations governing conduct inside.
You do have a right to be here.
Yeah, John.
You just don't have a right to be here and record without permission.
I'm sorry, the First Amendment gives me that right.
It does not in this building.
No, this is a federal courthouse, particularly in this building.
According to our local court rules by our district judge.
Okay, where's the order? Where's the signed order? In order for there to be rules, there has to be a signed order. There has to be a signed order. Go get the order. Go get the signed order.
Y'all Freemasons, I think y'all Freemasons, brother. All of them come against me and I prosper. If you touch me, brother, my God will deal with you. And my God already dealt with three fingerprints over there on Wall Street. He is. I don't know what happened. I hope to meet you one day and be able to tell them.
Well, how long you guys want to hang out with us today?
As long as it takes until you get it, until you get the point.
What's the point? Explain to you still haven't explained me the point. The point in coming in here every day and video this building.
No,
What is the point?
he has not been here after that. Has not been
I'm
here.
not I'm talking to him about it.
Yeah,
So
that's
the point
my
is,
point.
what's the point?
That's my partner. So,
Why are you here?
it's
Explain. If you don't have business
I've never
here,
been in this place before. I've always been on the outside and the inside, and this is a beautiful building.
it is nice.
So, look, John, if I was in your shoes, this is what I would have done.
I came over here to find out how to file a complaint on you. You showed why.
This is still an amazing situation.
Well, right now, you guys, we got a screening station here.
I want to see. No, it's not. Not before the screen. Go get a judge. Go get a judge. No, you're not. Okay, we're going to see what the judge says about that, because I do have a complaint already filed up, drafted up.
So here's our
I'd like to see a judge.
If this is a secure facility,
I'd like to see a judge.
Listen, you're not going to sit in here and yell and be disruptive. Either you're going to follow our rules or you're going to go to jail. Which is it? Which is it going to be?
What's your rules?
You're not going to come in here and be disruptive.
Okay, I'm not being disruptive.
Well,
I want to speak to a judge. I'm not yelling at you. I'm not. I wanted to speak to a judge.
Calm down. Have a conversation with us. Otherwise, you go to jail.
So that's the second time you threatened arrest.
That's not a threat. That's just me telling you what.
No, I'm not doing anything. I simply said that you're gonna show me either a signed order or a judge, or I have every right to call out for a judge.
Well, there isn't a judge here. Here's the local rules right here, where it says. You want to read it? Can you, Mr. Reardon? You were in Mississippi just the other day, right? Is that correct, Matthew?
I travel all around the country. I travel all around the country.
Right here, where it says local rules. You read that?
they got the rules right there.
Yep.
You want to read that right there? So these are our local rules here at this courthouse here in the Western District of Louisiana.
Guess what? They don't trump the federal the rules and
That's
regulations.
going on right here.
I'm challenging.
Okay.
I challenge you.
Come in. What do you want to do? You want to come in?
No, I'm in where I'm allowed to be right now.
Come into the building.
I'm in where I'm allowed to be right now.
You don't want to go anywhere else?
No.
Okay. Okay.
No, I'm where I'm allowed to be right now.
You just sit tight. All right? There's no guys.
I'm just videotaping, but
Yeah.
I know it's
Well,
not
I want to be able to do a pat down on you guys.
No, I don't consent to search and seizures.
If you're in the building, you can do it.
You're not gonna.
But
You right now, you two guys are.
You can't do that. That's a Fourth Amendment violation. That's a Fourth Amendment violation.
You know? So, I mean, you're in a federal building.
Hey, get back.
So why not?
Get back.
You know? Just step on out here.
No.
You don't want to be able to submit to a search?
No.
Huh? Matthew?
You're not going to touch me. I told you what's going to happen if you touch me.
I'm not touching you, Matthew. I'm not touching you. I'm not touching you.
I have every right to defend
just having a
myself legally.
conversation.
If you put your hands on me, I have every right to defend myself legally.
Just having a conversation.
you're a little too close.
Just having a conversation.
I know he's way too close. He's way too close.
Just having a conversation. Man. You guys are.
Just like
Yeah.
we got, but
Okay.
I know.
you got a decent little.
So, do you guys have any bits?
Oh, this is gonna be great content. This is great content right here. I don't give a shit. I don't care if you consent or not. Your consent means nothing to me. It means
Just
absolutely
like the
nothing to
rule
me.
of law means nothing to you, right? You don't care about
The rule of law. If the rule of law cared anything about you, the First Amendment doesn't matter to you. The Constitution doesn't matter to you because you won't even read the rules and regulations governing. No.
So when I asked you, when you want me to read
What's
it,
your
you
name?
don't want to read it.
You attack dog.
He's not answering questions. He's not answering
What's your
questions.
name?
He's not answering questions.
Oh yeah, but y'all can get in my face,
He's not
right?
answering
But
questions.
y'all can get in
He's
my
not
face,
answering
right?
questions. I'm the one answering
Y'all can get in
questions.
my face, though, right?
Yes, sir. Yes, sir. Yes, sir. I'm the one answering questions.
Oh, who do we got here? Name and badge numbers, please. Y'all are on the internet. Name and badge numbers. FBI? FBI?
You're not going to be talking to these folks like that.
I said name and badge numbers. I can talk to them. I can ask name and badge numbers.
You're not going to be disruptive. Come in here and be disruptive. So either you can walk out or be arrested, which is it going to be?
Oh, so it's under threat of arrest. So if I don't walk out, I'm under arrest.
You're in
So-
there being disruptive.
No, I'm not. I asked for name and badge number. I asked for name and badge number. I asked for name and badge number. So that was under threat of arrest, correct? It was under threat of arrest,
You're
correct?
in a public building.
So it was under threat of arrest, correct? Under threat of arrest? No, I heard it. He already said it. He already said it. It was under threat of arrest. Just tell me it's under threat of arrest. Just tell me it's under threat of arrest. Just tell me it's under threat of arrest, and I believe you. Just say it. Just say it. It's under threat of arrest, and I'm turning around and leaving. Just say it. Just say it.
One that got arrested for stalking the mayor in Oxford too.
No, that was all bullshit. Yeah, that was all set up. Yep.
Do you think what you're doing here?
Nope. I'm actually in a public building, and you can't. I'm in a public. I'm in a public building.
I think he's been drinking today.
No, he has not. I'm a witness to it.
You've been drinking today, have you not?
Oh, here we go. Here comes the gaslighting. I haven't drank in 5 years, motherfucker.
You have been.
I have not. Oh my God. I've been
he
in his house all fucking day. I've been in his house all day.
You like the drink? You like the sauce?
Oh, I can't wait. It's your fucking ass. It is your fucking ass.
He lives with me. He has not been drinking.
Exactly.
Devil come out.
He hadn't touched anything. I hadn't touched alcohol in 5 years.
You just got arrested last week for a DUI.
And guess what? The toxicology report showed no alcohol in my blood. Dumb motherfucker. Let's go. Yeah, I got enough content. Hey, you're gonna be famous on the internet.
So you can definitely hear the inconsistencies with the report. They speak for themselves. That's why I record everything. That's why everybody should always record everything, every conversation that they have with the government, because that's what they do, is they lie and they gaslight. And then as you can see, this is taking it a step further where they're actually reaching across state lines, and this is part of a broader conspiracy to silence my voice and to attack a journalist. It's not enough that they've done the things that they've done. It's not enough that I spent a year and a half locked up for a false charge from Galveston. Not enough that the prison sentence got vacated because it was illegal. Not enough that my private information got doxed out to 139 police officers up in Utah. They want to continue this attack further. And they wonder why I go out and I record in public buildings and I record the government. They created this monster. For the idiots that are watching this live stream that are with the U.S. Marshals Service, with the Department of Justice, with the Lafayette County Sheriff's Department, with the Oxford Police Department, with the Galveston Police Department, with the Layton Police Department. I am a result of your corruption, of your conspiracy. You have created this monster that you hate. You have created this person that you are putting bolos out on. And guess what? I'm only going to do it more and more and more and more. I'm going to record every single federal building I come in contact with until the Department of Justice decides to get off their ass and actually do something about this. I'm going to hold them accountable. I'm going to record. I'm going to be well within my rights. And I'm going to sink as many careers as I can possibly think in the government. What I'm going to do, you can hold it, you can hold me to that. That's what I will do. 100%. I am out to destroy as many careers with the people that get in my way. And that's not going to stop. I'm not committing any crimes. I'm exercising my rights as a journalist. You've created this monster. And I'm going to expose it the entire time. Just like I'm exposing it now. And these records that are redacted, they're not going to stay redacted for long. They're either going to get unredacted on appeal, or a lawsuit's going to be filed, and we'll take this all the way up until a judge actually grants the release of these redacted records. Take it to the bank. I'm absolutely livid. But I can't say that I'm surprised. Because my intuition has told me to make these public record requests where I've found out this information. And I'm not going to stop digging and finding more and exposing more of the institutional rot that is going on within the government, both on the state side and on the federal side. With that, I'm going to end the live stream. I've got things I've got to do. There was actually mention of a couple of courthouses that they said that I'll show up to at some point. I think I'm going to go show up there. And I think we need to be reminded about what the government does, about gaslighting being their number one weapon, their number one turn-to weapon. We'll end this live stream right now. The gaslight anthem. And just know, you're not going to intimidate me off of doing what I'm doing. When you get pissed off and mad that I'm doing it, take an internal look. Because it's the people that are angry about what I'm doing. It's the reason why I'm doing it. I'm going to go audit a courthouse. I'm going to go audit some public buildings. I'm going to be the biggest thorn in their side they've tried to make me out to be. Rest assured, take that to the bank. And to the Mississippi Highway Patrol, I'm going to find out every single roadblock you have posted. I'm going to blow the whistle on it. And if I can get there, I'll be on the side of the road raising hell, making your job as difficult as possible since you didn't want to do your job and exposing the bad cop that assaulted you. Take that to the bank. So you're tuning in live for National Fuck the U.S. Marshals Day. This is We the People News. We're live outside the John M. Shaw United States Courthouse, where these tyrants with the U.S. Marshals Service think that it's okay to criminalize journalism and the First Amendment. Had bolos put out. You ought to see, like, those that haven't seen the evidence, haven't seen the FOIA request. I knew that there was funny business going on. Y'all want me to come in? Hey, they're trying to wave me in the courthouse. So he just waved me in. Should I accept the invitation? I think I should accept the invitation. Hello. After you. Well, look who it is. Okay, you called me in here. You son of a bitch, I was outside on the fucking sidewalk. You told me to come in here, motherfucker. I'm going outside. You called me in here, motherfucker. You baited me in here, you piece of shit. Fucking pussy. You fucking pussy. Fuck your mom. He literally waved me in here. He told me to come inside. Was grinning and then told me he was going to throw me in handcuffs as soon as I walked in the doors. A public building. A public building. I'm holding my ground. I'm holding the line. Got to hold the line. And you're well within your rights. You cannot get pushed away. I mean, you give them an inch and they take a mile. Got to hold the line, folks. Got to hold the line. Huh? I'm on public fucking property. Let's go. Let's go. No, you're not. I'm getting it. You ain't gonna touch my camera. You ain't touching my camera. You ain't touching my camera. I'm getting my camera.
You grab the camera and you move it right now. If you don't, I'm seizing this camera.
That's right.
That is absolutely right.
So what? So this door.
You've got 1 second.
This door is locked.
You've got 1 second.
This door is locked.
This is an entryway. We're on the other side of the barricade.
I'm right. I'm fine right here.
2,
I'm
1.
really. Oh! Ah! Ah! Oh! Ah! Ah!
Congratulations. To the right to remain silent. Say again, we'll get Law. All right, consult an attorney. Attorney present. Question.
I want an attorney. I want an attorney.
In 1971, the court drew a line in Cohen versus California. Paul Cohen's "fuck the draft" jacket wasn't polite, but it was speech. Justice Harlan's reminder: one man's vulgarity is another's lyric, wasn't just clever phrasing. It was constitutional bedrock. The First Amendment protects the raw and the uncomfortable, because power doesn't get to dictate tone. 17 years later, NWA pushed that line further. Fuck the Police was banned from radio, condemned by politicians, and earned the group a warning letter from the FBI. But it survived. Not because gatekeepers approved, but because courts had already established in cases like Cohen that profanity and anger are protected when they are political speech. The music didn't just survive. It became an anthem against police abuse, echoing what the court had acknowledged years before. Offensiveness is not a crime. Now in 2025, I found myself living that same fight in flesh and bone. My camera was my lyric, my audit, my anthem. Yet the U.S. Marshals tried to crush it with fists instead of bans. They treated journalism like contraband, seizing equipment as if recording itself were illegal. They dragged me into cells, beat me, mocked me, and tried to rewrite the law with violence. What they could not silence with statutes, they tried to silence with shackles. The irony is bitter. The FBI once threatened NWA for words. Today, federal agents brutalize citizens for cameras. Tools of transparency. Both reveal the same truth. When speech exposes authority, authority will try to call it dangerous. Through FOIA, I had already uncovered evidence of U.S. Marshals Service bulletins and BOLOs targeting me, documents redacted so heavily you could barely read them, but enough to show they were treating journalism and First Amendment auditing as crimes. Those documents foreshadowed what came next. And now, because of what has happened, those pages must be unredacted. The conspiracy is no longer theoretical. It is lived proof. On August 25th, 2025, outside the federal courthouse in Lafayette, Louisiana, Marshal Hayden Newsom ordered me to move my camera away from a locked courthouse door. He threatened to seize it if I didn't comply. I complied. I backed up with my tripod and 4K camera in hand. That's when he attacked. He slammed me to the ground. My brand new gimbal was destroyed. My tripod shattered into pieces against me and underneath me. My 4K camera was wrecked. He violently accosted me as if press equipment was contraband. They dragged me into a holding cell. That's where Newsom drove his knuckles into my chest while I struggled to breathe. My heart was pounding, 140 to 160 beats a minute. When I knocked his arm away to stop the pain, he threatened me again and again. Assault on a federal officer. They laughed while I gasped for air. They delayed calling 911 for nearly an hour. When the paramedics finally arrived, they mocked me, saying I was just trying to delay jail. At the hospital, the indifference continued. Dismissive, condescending, unwilling to acknowledge the injuries inflicted by federal hands. When I was discharged late at night, Marshal Newsom shackled me and handed me off to Deputy Olivet of St. Martin Parish Jail. I asked before he even pulled out of the lot, "What am I being booked on?" Deputy Olivet admitted there was no charge, just a hold for the U.S. Marshals. I told him directly, transporting me without charge is kidnapping under 18 U.S. Code 1202. He claimed he was following orders. I reminded him of Nuremberg, that just following orders is never a defense. He drove me anyway. At St. Martin Parish Jail, the abuse escalated. Deputy Olivet and a female booking officer nearly broke my wrist, hoisting me by handcuffs ratcheted down so tight I could feel my bones grinding. It was torture, plain and simple. They threw me into a tiny freezing cell with only a torn blanket. I had no food the entire day. I lay on concrete in pain from my chest, my wrist, my ribs, mocked by guards who treated my suffering as entertainment. And all the while, the marshals laughed about what they had done, laughing at destroyed equipment, laughing at a broken body, laughing at constitutional rights discarded like trash. This is not law enforcement. This is not justice. This is a conspiracy. One already foreshadowed in the FOIA records. One that is now spilled into the open through violent arrest, torture, medical neglect, and unlawful detention. In 1971, the Supreme Court said the government cannot criminalize vulgar speech. In 2025, the U.S. Marshal Service tried to erase that ruling with fists, with broken equipment, with shackles and cold cells. But here's the truth. They failed. I'm still here. I'm still speaking. And I will not stop. Because history will not absolve those who hide behind just following orders. It will remember those who stood. This is the warning. This is the record. And this is not the end.
Who you need?
I need the sheriff if he's in.
You need the sheriff, like the sheriff himself, or is it a sheriff deputy?
I need the sheriff himself. I was actually the guy that was there the other day where the local police as well as the sheriff's deputy showed up outside of the St. Martin Parish Jail. What happened were major civil rights violations, and I need to speak to the sheriff about that.
All right, what I'm going to do is I'm going to transfer you to his secretary.
All right.
All right, sir, hold on.
St. Martin Parish Sheriff's Office.
Is the sheriff still in? What's that?
This is his assistant. How can I help you?
Yes, I'm calling actually. I need to speak to the sheriff. This is a major issue that honestly requires the sheriff's attention. This is Matthew Reardon. I was over there at the jail 2 days ago, September 19th. And the local police showed up as well as the sheriff's deputy. And what happened right there is a major thing. What happened at the jail was a major thing. Back on August 25th of this year, my camera gear was broken over me. I'm a journalist. I was outside of the federal courthouse in Lafayette, and my camera gear was broken over me by the U.S. Marshals. And I was passed off to Deputy Olivier at the hospital parking lot and told to be taken to the St. Martin Parish Jail. I told Olivier, I said, what charge am I being charged with? And he said, I don't have a charge. It's just a hold for the U.S. Marshals. I said, no, you can't do that. That's kidnapping. Due process requires that in order for you to take a free man, lock him in a cage,
there has to be a charge. I told him to get a supervisor, that if he continued forward taking me to the jail, that ultimately that's putting his qualified immunity on the line. He never did. We're on the way going to jail, and I just know that this is something horrid and dark that was set up, and we're getting close to the jail, and Olivia says, he asked me, please cooperate when we get there to the jail. And I told him, I said, I cannot participate in my own kidnapping. I have a duty and an obligation to not comply on something like that. There's no charge. Get to the jail. He calls one of the booking guards. She's a bigger black woman. And she comes out there. My handcuffed down about as tight as they could be. And they pick me up by the handcuff chain, nearly breaking my wrist. I'm screaming in pain as I was carried to the front desk of the jail. I was treated absolutely horribly in that jail. I've never seen such a just complete disregard for constitutional rights, for civil rights, and it'd be a laughable joke. I was ordered released by the judge the next day. And I feel like I know they were up to something. Well, I went back to the jail 2 days ago on the 19th because I wanted to serve a legal demand to preserve evidence. So I'm letting the county know that any video from the Sally Port, from the booking area that captured this crime being committed must be preserved. I have it in writing. What I would like is, I haven't even gotten into what happened 2 days ago. That was a joke right there. My rights were violated yet again. And if I have to come back there in person, it's going to be conflictually based on the past. So I would like the county to take receipt of my legal demand to preserve evidence electronically.
I'm going to have our legal counsel contact you. Is it this contact number 66258?
Yes.
And your name's Matthew Reardon?
Yes.
And you were arrested on August 25th by which agency?
I was kidnapped by the U.S. Marshals, and then your agents took receipt of me. Yes.
Olivier or Olivier?
Olivier. Olivier.
Okay. I just need some clarification.
Yeah. Hey.
And U.S. Marshals kidnapped you where?
So let the legal counsel know that as a journalist, I'm publishing to We the People News. Kidnapped. I'm gonna let him speak directly to you. U.S. Marshals kidnapped you. Where were you kidnapped? In St. Martin Parish or you Lafayette Parish? I was in Lafayette Parish.
You were in Lafayette Parish.
Yes.
And you were transferred to our jail.
So I was taken to the hospital. The paramedics, when they eventually called them over at Lafayette, when they had me in the back of the Lafayette courthouse, the paramedics showed up an hour later, and my heart rate was between 140 to 160 beats a minute. I couldn't breathe. I was in so much pain. And they were so dismissive, saying, we just think he's just trying to get out of going to jail. That's bullshit, because I wasn't even charged with the crime.
Okay. Spell your last name for me.
Reardon. But yeah, I was discharged from whatever hospital they took me to late at night, and Olivier took me in shackles. They shackled me up. Olivier took me, and in the car, I asked about the charge. And then he told me that he was basically taking orders. And so I gave him the story about Nuremberg and the Nuremberg trials, and how when the Nazis gassed the Jews and then tried to say that they were just following orders, that didn't cut it. They were held to account, and I'm holding them to account. I told Olivier that night that I was going to strip him of his qualified immunity if he continued on, and he did. And then he took part in my torturing. It was a brutal torturing, being picked up by the bones in your wrist. It's horrible pain. And so I swear I'm going to strip him and anybody that had, any dealings of it, of their qualified immunity. There's no question about it.
Okay. I'm going to have our legal counsel contact you, Ms. Matthew, and we'll be back in touch with you, okay?
Okay, so can y'all, I just need to know that as of this date, y'all have been made aware.
No, I'm not. No. I'm not accepting any of that, and I'm sure you're probably recording, and I'm asking you not to record.
No,
You are going to speak to our legal counsel. I am not going to accept anything by your word. So what I'm saying.
And she hung up on me. Well, I was simply trying to make sure that the county had understood its legal obligation. There's now two parties to a case. There's now an accusation that's been made. There's an accuser, and there's the accused. And now there must be a trial. My name is Matthew Reardon, and I stand before you today not as a defendant accepting the legitimacy of kangaroo proceedings, but as a journalist documenting the wholesale destruction of the American constitutional order. On August 25th, 2025, I was arrested at the John M. Shaw United States Courthouse in Lafayette, Louisiana, for the alleged crime of journalism. Let that sink in. In the United States of America, in the year 2025, federal marshals violently arrested a journalist for documenting government activity on the front steps of a public courthouse. But this case stopped being about a single arrest the moment the government made a choice, a deliberate, calculated choice, to destroy the evidence that would prove my innocence. Let me be crystal clear about what happened here, because the government is counting on you not understanding the technical details. They're counting on you accepting their lies, and I won't let them. On September 8th, 2025, just 2 weeks after my arrest, my federal public defender, Dustin Talbot, sent a detailed preservation request to the U.S. Attorney's Office. Not a vague request. Not a general inquiry. The precise, itemized demand for surveillance footage from June 23rd, June 26th, and August 25th, 2025. The request was copied directly to Supervisory U.S. Marshal John Farish, the man who oversees the very agents who arrested me, and to the clerk of the court, Daniel McCoy. That preservation request described exactly what we needed. All surveillance recordings. Phone is messing up. All surveillance recordings from the John M. Shaw United States Courthouse that depict the front steps, the front entryway, the foyer, or any other area of the courthouse building or grounds that were visited by Matthew Reardon. Think about that timing. September 8th, less than 15 days after the incident, long before any footage would naturally expire from the system. This was immediate. This was proper. And this was legally binding. The government had one job: preserve the evidence. The most basic, fundamental obligation in any criminal prosecution. Preserve the evidence. They didn't. On November 20th, 2025, after months of my defense attorney asking, "Where's the surveillance footage?" The government finally responded. And here's what they said in writing, filed with the federal court in document number 44. Data footage from several camera locations were unable to be preserved due to a technological error in the recording system. Technological error. How convenient. Same government that can track every phone call, every email, every digital footprint of every American. The same government that operates the most sophisticated surveillance apparatus in human history suddenly has a technological error that just happens to destroy the one piece of evidence that would definitively prove whether I committed a crime or was peacefully engaged in constitutionally protected journalism. But here's the problem with lying in federal court. Sometimes the truth has a way of emerging. Through a Freedom of Information Act request, I obtained a document that obliterates the government's entire story. It's a single surveillance still image produced by the U.S. Marshal Service themselves, dated June 23rd, 2025. Let me read you the Bates number so there's no confusion about what we're looking at. 2025 USMS FOIA /PA 000412, page 9 of 14. This image shows me at the courthouse entrance. It was captured by an interior lobby camera. The timestamp is intact. The camera ID is intact. The metadata is intact. This isn't some degraded, corrupted file. This is a clean, clear, perfectly preserved surveillance still exported from the exact same camera system that allegedly suffered a technological error 2 months later. Now let me spell this out because it's critical. June 23rd, 2025. June 23rd, 2025. The surveillance system works perfectly. The marshals capture footage of me. They preserve it. They export it. And they circulate it in a bolo. Be on the lookout alert. Treating a journalist as a security threat for engaging in constitutionally protected activity. August 25th, 2025. I'm arrested. 2 weeks later, my attorney sends a preservation request specifically identifying the dates, the locations, the camera coverage needed.
November 20th, 2025. The government claims technological error destroyed the footage from August 25th. But somehow, the footage from June 23rd survives just fine. Do you understand what this means? The same system, the same cameras, the same courthouse, the same surveillance infrastructure. It works perfectly when the government wants to use it to target me. But it fails catastrophically when I need it to defend myself. This isn't a technological error. This is evidence destruction. This is spoliation. This is obstruction of justice. This is the United States government engaging in the very crimes it prosecutes citizens for every single day. But the evidence destruction isn't where this story begins. It's where their cover-up fell apart. To understand what really happened here, you need to see the full pattern. Before August 25th, before they arrested me, before they charged me, before they claimed any crime occurred, the U.S. Marshals were already coordinating with federal judges about me in secret. Ex parte communication. That's the legal term. It means the government talks to the judge about a case without the other party present or even knowing it's happening. It's one of the most serious forms of judicial misconduct. It's a due process violation at the most fundamental level. It's the kind of thing that gets judges removed from cases. And it happened here. The U.S. Marshals, the same ones who would later arrest me, the same ones who would later control the surveillance footage, the same ones whose conduct is at the center of this case, were having private communications with federal judges about Matthew Reardon before I was ever charged with anything. Think about the timeline. June 23rd, 2025. The Marshals capture surveillance footage of me engaged in constitutionally protected journalism. They don't arrest me. They don't charge me. They surveil me. They circulate bolos, treating a journalist as a security threat. Between June and August, ex parte communications occur between U.S. Marshals and federal judges. These aren't public. They're not on the record. I have no attorney present. I have no opportunity to respond. I don't even know they're happening. August 25th, 2025. The incident occurs.
I'm violently arrested. I'm charged with a petty offense that carries the force of the entire federal prosecutorial apparatus behind it. After the ex parte becomes known, federal judge recuses herself from the case. Let me repeat that. A federal judge found the ex parte communication serious enough that she could not continue presiding over the case. That doesn't happen for minor procedural irregularities. That happens when something has fundamentally compromised the integrity of the proceeding. And here's the truly damning part. Before that recusal happened, the government moved to gag me and my attorney from even discussing the ex parte communication publicly. Read that again, slowly. The government, 1, engaged in secret communications with judges before charging me. 2, got caught. 3, immediately moved to gag us from talking about their misconduct. 4, only backed down when the judge recused. This is consciousness of guilt. This is cover-up behavior. This is the government trying to hide its own misconduct using the power of federal court to silence its victim. Now, do you see why the technological story or the technological error story falls apart? This isn't a government that makes innocent mistakes. It's a government that targets journalists before any alleged crime occurs, coordinates secretly with judges in violation of due process, moves to gag its critics when caught engaging in misconduct, destroys exculpatory evidence after receiving specific preservation requests, adds a second, let me repeat that, adds a second federal prosecutor to crush a petty offense charge while hiding evidence. Each of these acts standing alone might be explainable. Maybe there's a legitimate reason. Maybe it's just an unfortunate circumstance. Maybe we should give them the benefit of the doubt. But all of them together in sequence in a case about government accountability and First Amendment journalism. That's not a pattern of errors, folks. That's a pattern of systematic constitutional suppression. And here's the truly Kafkaesque part of this nightmare. The very people who destroyed the evidence are the same people who arrested me. The same U.S. Marshals who claim I committed a crime are the exact same individuals who were entrusted with preserving the evidence that would prove whether that's true. Do you see the conflict of interest? Do you see the constitutional crisis embedded in this arrangement? The accused, the U.S. Marshals, controlled the evidence about their own conduct. They receive a preservation request. Let's call it a demand, what it was. They ignore it. They claim technological error. And then they expect a court to simply accept their word. This would be like allowing a murder suspect to control the crime scene, dispose of the evidence, and then show up at trial saying, "Sorry, judge, technical difficulties. The DNA just disappeared." No rationale justice system would permit this. But that's exactly what's happening in federal court right now. The government's response tries to dodge this issue by claiming the surveillance footage is not in the possession or control of the U.S. government. That's a lie so transparent, it insults the intelligence of everyone who hears it. The U.S. Marshals Service operates within the Department of Justice. They control courthouse security operations. They authored the incident reports. They coordinated with courthouse IT and contractors. They had practical access to the surveillance system. They successfully preserved and exported footage from June 23rd. The footage was and is in the government's possession, custody, or control for purposes of Federal Rule of Criminal Procedure, Rule 16, and Brady v. Maryland. The government cannot credibly disclaim possession or control of surveillance infrastructure it operates and supervises. They can't have it both ways, claiming security jurisdiction over the courthouse while denying access to the security footage when it becomes inconvenient. And here's where we get to the question that cuts to the heart of whether this proceeding has any legitimacy at all. On one side, Matthew Reardon, one journalist, one attorney, zero ability to compel evidence from federal agencies, zero ability to investigate federal agents, zero ability to prevent evidence destruction, facing criminal charges that can leave a lasting impact on his life. On the other side, the United States government. 2, federal prosecutors. They added a second one to this petty offense case. The full investigative power of the U.S. Marshals Service, the full surveillance apparatus of the federal government, exclusive control over all evidence, the ability to secretly communicate with judges, the ability to destroy evidence and call it technical error, the ability to move for a gag order against their critics. How can that ever be considered fair? They provoked this incident. Don't get it wrong. They provoked it. They had ex parte communications. They moved to cover it up with a gag order. And then they destroyed the evidence. And now they've doubled down by adding a second prosecutor to crush me. This isn't prosecution. This is persecution. This isn't justice. This is the power of the state weaponized against a citizen who dared to document its misconduct. And here's why the ex parte communication is so critical to understanding the evidence destruction. The technological error defense only works if you believe this was an accident, an unfortunate malfunction, a regrettable but innocent failure of technology. But the ex parte communication proves they were already focused on Matthew Reardon before August 25th. They were already treating me as a problem to be solved. They were already coordinating with judges about how to handle the Matthew Reardon situation. So when that surveillance footage, the footage that would prove what actually happened, mysteriously disappears after a specific preservation request, we're not talking about an accident anymore. We're talking about the predictable next step in a campaign that started with surveillance, escalated to secret judicial coordination, got exposed, triggered a cover-up attempt through a gag motion, and culminated in the destruction of evidence. Each step was deliberate. Each step was calculated. Each step was designed to neutralize a journalist who was documenting government misconduct. The technological error is just the latest lie in a series of lies that started the moment they decided I was a threat to their power. And let's talk about the addition of a second prosecutor, because this tells you everything you need to know about how seriously the government takes its campaign against me. This is a petty offense. That's the government's own characterization. This isn't a murder case. This isn't terrorism. This isn't espionage. This is allegedly standing in the wrong place on courthouse steps. A CFR, loitering, making loud noises, disorderly conduct, blocking a locked door with a camera that got moved when the marshal threatened to seize it. For this petty offense, the federal government has assigned 2 United States attorneys. Think about the resources that represents. Think about the message that it sends. Think about what it means when the government deploys that level of prosecutorial firepower against a single journalist for a misdemeanor level charge. It means they're not trying to achieve justice. They're trying to achieve destruction. They're trying to bury me in legal fees, in court appearances, in the grinding machinery of federal prosecution. They're trying to send a message to every other journalist, every other activist, every other citizen who thinks about holding government accountable. This is what happens when you document us. Meanwhile, they control all the evidence. They destroyed the most important evidence. They had secret communications with judges. They tried to gag me from talking about their misconduct. And they want to call this a fair trial? Let me be specific about what that destroyed surveillance footage would have shown. Because the government is counting on you not understanding exactly what they took from me. That footage would show whether I actually obstructed an entrance or was standing peacefully on public steps in a traditional public forum where the Supreme Court has repeatedly confirmed citizens have an absolute right to assemble and speak. Whether the door I allegedly blocked was even functional or was locked, as I maintained and still maintain and will always maintain, making obstruction of a non-functioning entrance factually impossible. Whether any member of the public was actually prevented from entering the courthouse, because the statute requires that I unreasonably obstructed the usual use of entrances. And if no one was actually obstructed, there's no crime. Whether I complied with martial commands or resisted, because compliance versus resistance is the difference between lawful journalism and criminal conduct. Whether the marshal's testimony about my conduct is accurate or fabricated, because that footage is objective evidence that cannot be disputed, while testimony is subject to bias, faulty memory, and deliberate misrepresentation. And most importantly, whether the marshals waved me up to that location from where I was peacefully standing by the road, because if they provoked the confrontation by directing me to a location they would later claim was restricted, that's entrapment. In other words, that footage is the ball game. It's dispositive. It's the difference between guilt and innocence. It's the difference between a criminal and a journalist doing exactly what the First Amendment protects. And the government destroyed it. Not accidentally, not through negligence, through deliberate spoliation after receiving specific notice to preserve it. For those who understand criminal law, what we're dealing with here are Brady and Giglio violations of the most egregious kind. Brady versus Maryland. Established that prosecutors must turn over exculpatory evidence, evidence that tends to prove innocence. Giglio versus United States extends this to impeachment evidence, evidence that undermines the credibility of government witnesses. The destroyed surveillance footage falls into both categories. It would exculpate me by showing I engaged in protected First Amendment activity and complied with lawful orders. It would impeach government witnesses by providing an objective record against which their testimony can be measured. The government cannot simultaneously claim they don't have the footage and avoid their Brady and Giglio obligations. If they destroyed exculpatory evidence after receiving a preservation request, that's not just a discovery violation. It's a due process violation that goes to the heart of whether any fair trial is possible. Courts have consistently held that when the government destroys evidence in bad faith, the appropriate remedy includes dismissal, adverse inference, and sanctions. The government's conduct here, destroying evidence after a preservation request in a case where they had ex parte communications and then moved to gag the defendant, demonstrates bad faith so clear that only the most severe of sanctions can restore any semblance of fairness. I need you to understand something. This is not about me.
This is about a pattern. This is about a system. This is about what happens when the government decides your constitutional rights are inconvenient. I've been systematically targeted across multiple jurisdictions for the crime of holding the government accountable. Federal charge here in Lafayette. Multiple over in Mississippi. It's been a witch hunt for 8 years. At every turn, I've documented in excruciating detail the patterns of corruption, the coordination between agencies, the judge shopping, the ex parte communications, the selective prosecution. And at every turn, evidence disappears. Recordings are lost. Footage suffers technical errors. Witnesses become unavailable. Documents go missing. This is not incompetence. This is policy. This is how the system crushes dissent. This is how the government neutralizes journalists, activists, and anyone who dares to document its crimes. The pattern is clear. Surveil the target. Coordinate with judges. Provoke a confrontation. Arrest on pretextual charges. Destroy the evidence. Deploy overwhelming prosecutorial resources. Exhaust the defendant financially and psychologically. And extract a plea or conviction that validates the initial targeting. Each step reinforces the next. Each abuse enables the following abuse. And if nobody stops it, if courts simply accept technical errors and unfortunate circumstances, then the pattern continues until the Constitution becomes a dead letter. This case has always been about the First Amendment. From day one, this has been a brazen attempt to criminalize journalism, to weaponize federal law enforcement against a citizen documenting government activity in a public forum. The courthouse steps are a traditional public forum. The Supreme Court recognized this for decades in cases like Perry Education Association versus Perry Local Educators Association, United States versus Grace, and countless others. Citizens have an absolute right to assemble, protest, to document, to speak freely in that space. This is not disputed. This is not controversial. This is bedrock constitutional law. But the federal government doesn't care. They arrested me anyways. They charged me anyway. And when I demanded the evidence that would prove my innocence, they destroyed it. It's the government sending a message: document us, and we will fucking destroy you. Challenge us, and we will fucking destroy the evidence. Demand accountability, and we will fucking bury you in a system
that has no accountability for itself. Every journalist watching this needs to understand this is what happens when you do your job. This is what happens when you document government conduct, or when you document government misconduct in public spaces where you have every legal right to be. This is what happens when the government decides the First Amendment is negotiable. This is tyranny. This is what a police state looks like in its early stages. This is how democracies die, not with sudden coups, but with slow, grinding procedural abuses that corrupt the justice system from within. The ex parte communications compromise judicial independence. The gag motion attacks press freedom. The evidence destruction denies due process. The deployment of 2 federal prosecutors against a journalist intimidates the press. Each abuse builds on the last until you wake up one day in a country where the government can arrest you for journalism and destroy the evidence proving your innocence. And courts just let it happen. That's where we are. That's what this case represents. That's why I will not participate in this farce. I stand before you today to say clearly, unequivocally, without hesitation, I will not bring myself to trial under my own power while this injustice stands unaddressed. I will not participate in a proceeding that was contaminated before it even began. I will not pretend a trial can be fair when the government coordinated with judges against me in secret before any charges existed. When the government tried to gag me from discussing their misconduct. When the government destroyed the most important evidence after receiving specific preservation requests. When the government deployed 2 federal prosecutors against a journalist for a petty offense. When the government controls all evidence, all witnesses, all institutional power. This isn't a trial. This is a theater. This is a kangaroo court. This is the government going through the motions of justice while systematically ensuring that no actual justice can occur. They want me to show up, sit down, shut up, and accept whatever punishment they've already decided that I deserve for the crime of journalism. They want this case to move quietly through the system so nobody notices the ex parte communications, the destroyed evidence, and the constitutional violations. I won't do it. I won't participate. I won't legitimize this farce with my cooperation. So I'm calling on everyone watching this, journalists, lawyers, civil rights advocates, citizens who still believe the Constitution means something, to demand accountability. When the government engages in ex parte communications with judges, moves to gag defendants from exposing misconduct, destroys evidence after preservation requests, deploys overwhelming prosecutorial resources against a single journalist, there must be consequences. Not procedural slaps on the wrist, but real consequences. Criminal consequences. I'm demanding that the court hold an evidentiary hearing on spoliation of evidence with testimony under oath from every U.S. Marshal involved in preservation decisions, every IT contractor with access to the surveillance system, and every government attorney who received the September 8th, 2025 preservation request. I'm demanding the court compel production of all ex parte communications between U.S. Marshals and federal judges regarding Matthew Reardon, including emails, text messages, phone records, and any memoranda documenting these conversations. I'm demanding the court produce all technical logs, export records, and chain of custody documents for the surveillance system, including system error logs for June through November 2025. Export logs showing what footage was successfully preserved, retention policy documents, and any communications regarding preservation or deletion of footage. I'm demanding the court issue an adverse inference instruction to presume the destroyed evidence would have proven my innocence, my compliance with law enforcement, and the falsity of government witness testimony. I'm demanding the court dismiss all charge, dismiss the charge with prejudice as a sanction for government misconduct that has irreparably prejudiced my ability to receive a fair trial. I'm demanding the court refer this matter to the Department of Justice Inspector General for criminal investigation of evidence destruction, obstruction of justice, and the deprivation of rights under color of law. I'm demanding the court refer the prosecutors who moved for a gag order to their respective state bars for disciplinary proceedings related to attempting to silence the exposure of government misconduct. These are not requests. These are the minimum requirements for restoring even a semblance of legitimacy to this proceeding. This case is bigger than me now. It's a test of whether the Constitution still constrains government power, or whether it's become a dead letter that judges cite while ignoring its actual requirements. It's a test of whether courts will hold law enforcement accountable when they coordinate with judges in secret, destroy evidence, and deploy overwhelming force against journalists. It's a test of whether journalism is still protected in America, or whether we've crossed into an era where the government can surveil you, target you, arrest you, destroy evidence proving your innocence, and then call it justice. The government has shown its hand. They've revealed themselves. They engaged in ex parte communications, serious enough that a judge recused. They tried to gag me from talking about it. They destroyed evidence and they added prosecutors. Every action reveals consciousness of guilt. Every action shows they know their case is illegitimate. Every action proves they're not seeking justice. They're seeking to make an example out of a journalist who documented their misconduct. Let me state this clearly for the record because I want there to be no ambiguity about what I'm alleging and why. I, Matthew Reardon, allege that the United States government, through the United States Marshal Service, the United States Attorney's Office for the Western District of Louisiana, and in all that, the Department of Justice, because they both fall under the Department of Justice, has engaged in evidence destruction in violation of Federal Rule of Criminal Procedure, Rule 16, Brady v. Maryland, Giglio v. United States, and my Fifth Amendment right to due process. I allege ex parte communications with federal judges in violation of my Sixth Amendment right to counsel and Fifth Amendment right to due process. I allege attempted suppression of speech through the and my phone just, it was right there at the end. My phone just lost power. No, this is a very serious ordeal. It's a very, very serious ordeal. Because if the government can provoke its own prosecution, and they can provoke it through running illegal surveillance on constitutionally protected activity, circulating bolos, they can cover up their wrongdoing, their serious wrongdoing, try to use their power to gag a defendant so that the public does not know, and to stack the deck so heavy, to destroy evidence. What does that mean for the next defendant? What does that mean for you if you fall into their crosshairs next? It's not just about whether or not I get convicted. It's everybody else. It's in line next. Because how can, when the government says that it's okay for one person to go that far outside of the bounds, and for it to be acceptable, to deny every aspect of due process, we no longer have a constitution. We're no longer a free society. We're living under tyranny.